On January 31st, South Carolina plans to execute Marion Bowman Jr., which would make him the third inmate executed after South Carolina resumed the death penalty following a 13-year pause. But Bowman's attorneys say that prosecutors at his original trial failed to disclose key evidence, and his own attorney infected the trial with his racist beliefs about Bowman. My name is Ted Clifford, and I'm the accountability reporter at the state newspaper in Columbia, South Carolina, where I cover the state's death penalty. Marion Bowman Jr. was convicted of murdering 21-year-old Candy Martin in the early morning hours of February 17, 2001, and setting her body on fire inside of a car in Dorchester County, South Carolina. At his trial the following year, James Twain Gadsden, one of Bowman's friends and the only other eyewitness to the shooting, testified that Bowman shot Martin, a young mother, over her pleas for mercy. And according to court records, Bowman was planning to commit a robbery that night, but became paranoid that Martin, who he had known for years, was wearing a wire. But Bowman's current defense team say that prosecutors failed to disclose a memo of an interview with a jailhouse informant who told law enforcement that Gadsden said he was actually the one who had shot Martin. Defense attorneys also say that prosecutors did not disclose important information about Gadsden's mental state, including that he was suffering from memory loss, blackouts, was hearing voices, and a beeping sound, in addition to smoking 6 blunts of marijuana a day at the time of the shooting. Additionally, prosecutors allegedly did not disclose a deal they had to drop unindicted charges against another key witness named Hiram Johnson. Now, all of this would be a violation of what's called the Brady Rule, a requirement that prosecutors turn over all material relevant to their case to the defense, and failing to do so can result in a judge ordering that the case be retried. But perhaps most shockingly is that Bowman's defense attorneys have argued that one of his original trial attorneys, a South Carolina lawyer named Norb Cummings, injected racial prejudice into the case. For instance, Cummings repeatedly drew comparisons between Martin, who he called a little white girl, and Bowman, who he described as a black man, when at the time of the murder, Martin was actually a year older than Bowman, who was just 20. Cummings also did not introduce credible evidence that Martin had a drug addiction and a history of prostitution, as well as pawning personal items for drugs, because he didn't want to slander Martin at the trial. Taken together, Bowman's current attorneys in a habeas corpus petition to the Supreme Court say that this call into question the reliability of the conviction and have urged the South Carolina Supreme Court to halt the execution so that these issues can be examined. So what are Bowman's chances? Well, at this point it's unknown, but in previous death penalty cases since the state resumed executions, the court has consistently ruled against the condemned and allowed executions to continue. So to keep up with the news on South Carolina's death penalty, follow along with our coverage at thestate.com.